you the opportunity to respond.
My view was that you entertain our objections first because we included them in our pleadings. That's the prayer we are seeking.
Basically, that they will first consider you.
Exactly, because we indicated it in our pleadings. We indicated it in our pleadings.
Does the order matter?
It does, because there is
what
notice.
is the impact of starting with the applicant?
You know what I'm saying? The law does not allow trial by ambush. It's the point I am making. If you want to raise preliminary objections, you indicate it in your pleadings.
Yes, but is it fatal if you don't?
It is, Your Honor, for the simple reason that you will have ambushed the other party.
For a point of law, it can come at any time.
It can.
Anyway, I'm overruling you. Let us hear from counsel for the applicant.
Most obliged, Your Honor.
We hear your response, then you
Most obliged. Most obliged, Your Honor.
So, go ahead with your points of law.
Your Worship, do I add them or I first
Outline them.
Your Worship, the first preliminary objection is against the affidavit in reply filed by one Municipal Allen.
Yes.
And our objection is as follows. One,
Yes.
he swears as an affidavit showing that he is an accredited media observer but there is no attachment of the letter.
No attachment.
There is no attachment of a letter issued by the Electoral Commission accrediting him as an election observer.
Maybe for clarity, would you take me to the paragraph where you get that?
You watch that is paragraph 1 and paragraph 2.
In para 5 and 2?
Paragraph 1 and 2.
Okay, showing that he's an accredited media observer.
In paragraph 2, for instance, it says that on 6 February 2026, I was accredited by the Electoral Commission as one of the journalists covered the aforesaid election.
So it is an accredited media observer for the Electoral Commission?
Yes.
Or by the Electoral Commission?
Yes, Your Worship. That is what I gather from paragraph 1.
So is it of, by?
That is a matter of law.
No. I mean, according to your submission. You're saying he says that he was accredited, or he's an accredited media observer for the Electoral Commission? According to your...
For the media house. That is next media house.
Oh, okay, for next media house. Okay, go ahead.
And he claims that...
So you're saying there's no attachment of a letter from?
From the Electoral Commission.
From the Electoral Commission?
Yes, Your Worship.
Your Worship, of guidance housekeeping. Housekeeping only. Your Worship, we are here to hear points of law. And I think my learned brother is confusing mistake of law, mistake of fact.
Like I say, there is room for a reply to the same. You're going to get your time.
Your Worship, to be, I'm not.
Irrespective of the points he's raising, you will get the opportunity to give your response, which I will definitely entertain. and I will make
what
a ruling.
what I'm trying to, what I want to get this court about.
Also, you seem to want to reply
No,
immediately.
what I'm trying to get this court about is that we may be arguing the application by going by paragraph rather than arguing the points of law. Because if it is just by matters of fact, we could wait and go by the application itself, present it, and argue it.
So let me ask, you want me to make a ruling at this time on whether there are matters of law, matters
Of course,
fact?
my objection can be overruled or sustained depending
No, I'm seeking your guidance. You want court to make a
No,
ruling.
I want your ship to guide court, to guide us as bench and bar
Now, for example,
on the limitations and
yes,
scope.
I heard from him. I expected to formally hear from you because I've not put you on record.
Yes.
To formally hear from you, I put you on record, then I guide. I thought that was the right procedure.
Most obligatory.
Irrespective of the submissions, whether it is merit or no merit, we listen. That is what we call a fair hearing.
Okay.
We give the ear. Yes.
Maybe Your Honor, I
Mm.
think for purposes of clarity, we want to take it that your guidance is that regardless of any deviations from either matters of law or procedure, we keep it to our replies.
I would expect that. In your replies, you will bring that out. Otherwise, when he's addressing court and you keep coming in, we end up wasting more time. Yet, when you're interjecting, I'm not putting you on record.
Most obliged.
So you will get the opportunity to reply.
Most obliged, Your Honor.
And I will take into account your submissions over the same or your reply. Then I will make a ruling. So, counsel, the floor is to yours. And I would request really that we give room to counsel who is making submissions on the floor, and after, then we can entertain the other.
With obedience, Your Worship, we have complied.
So you had stopped at the point where you told me that he swore or he averred how he was an accredited media observer, but there is no attachment of a letter issued by the Electoral Commission.
Yes, Your Worship.
Go ahead. So that is your number one PO?
Yes, regarding this affidavit, Your Worship.
Okay.
Then still on this affidavit, I take you to paragraph 5.
Maybe I would encourage you, can you finish up with that PO instead of highlighting, then we go back. We can handle PO by PO. You can give me your arguments.
So Your Worship, our argument on that is that the affidavit is incompetent because there is no evidence.
Because
There is no evidence attached to show that he was unaccredited.
attached to show
That he was an accredited election observer and therefore he lacks capacity to make this affidavit.
Is it by practice, by law, or where do you get that?
Your Worship, accreditation of election observers is a matter of law.
No, we are now talking about affidavits generally. We want to swear an affidavit. What are the requirements of the law?
Once you are swearing an affidavit in a certain capacity, then you have to prove that capacity, Your Worship.
That capacity.
Now
Okay.
here is swearing as an accredited election observer.
Over which body?
That is the Electoral Commission.
That is what is in the affidavit.
Yes, Your Worship.
Which paragraph does he say he was the accredited media? Observer
Paragraph
for
2
the-
reads that on the 6th of February 2026, I was accredited by the Electoral Commission as one of the journalists
Oh, okay.
covered Afro Assembly election.
Oh, okay. So failure to attach is fatal,
Yes, Your Worship.
and what is the implication?
The implication that the whole affidavit is in trial.
Collapses.
Yes, Your Worship.
What if he was present and was not having that evidence of the attachment you're talking about?
Your Worship.
I'm assuming what if he attended the exercise, but he lacks that document?
Then still there is no way you can swear an affidavit, Your Worship. Yes, because accreditation is a matter
Who is
of
supposed to swear an affidavit?
the same person who is claiming that he is accredited is the one who swore the affidavit.
No. Generally, who is supposed to swear an affidavit?
Someone who is well aware of the instances which are.
Of the instances?
If I'm aware of the facts
Mm,
relating to the case before court which happened,
mm.
I can swear an affidavit.
So if he was there, would your PO be sustained? Would you still raise the PO?
It still maintains.
Or maybe you're saying there's no
because-
evidence that he attended?
Because here, someone is saying he was accredited by the Electoral Commission to come and observe.
Mm,
Now, if he was merely saying that he's a journalist from the next media group who came observe, it's okay. But now once he says he was accredited by the Electoral Commission to come and observe, it becomes a different issue.
Okay, I've taken note.
Then, Your Worship, the second substantive clause is in paragraph 5 of that affidavit.
Of the affidavit of
That is still Nesigo Alan.
Mwesugwa.
Alan,
Mm.
where he says that we have been able to extract the video coverage of the entire time process. Your Worship, one person cannot swear as we.
Repeat that. We were able to extract.
That we have been able to extract the video coverage of the
Okay.
entire time. That is paragraph 5, Your Worship.
We were able to extract the what?
That we have been able to extract the video coverage
The video.
of the entire time process. Your Worship, the first issue in that paragraph is that one person is swearing as he, which is unknown in affidavit evidence.
It presupposes that.
One person that is Nesigo Alan is swearing as we. Under the law governing affidavit evidence, one person cannot swear as we. That is not
On behalf of another person.
on behalf of other unknown persons, Your Worship.
Okay.
Then secondly, still in that paragraph, they say a copy of the video coverage is here to attached and marked as Annexure A, but none is attached, Your Worship.
None is attached.
Yes. The affidavit, which was served on us. So, Your Worship,
Via you add-on, which was served on you via what? How was it served?
via WhatsApp. electronically.
Okay.
Meaning, if there was also it could have been served on us
Mm.
electronically.
Okay. Further alleged
It is still further alleged that
video.
the video coverage is here too attached and marked as Annexure A
Attached to the
to the affidavit
affidavit.
and marked as Annexure A,
Mm.
but none was
Which
attached.
video has not been served until.
So none was served on the applicant electronic
Okay.
ownership.
Noted. So, what is the impact of that PO?
We apply, this paragraph offends the rules of natural justice and Article 28,
Mm.
which requires that the opposite party must know clearly.
I mean, on first and foremost, the we. Now we have a combination of the we and the. We can start with the we.
Your worship, that also introduces in the hearsay evidence because
We
yes,
supposes
hearsay. This paragraph now becomes also hearsay evidence.
we presupposes hearsay.
Yes, your worship. Because also the names of those alleged people are not indicated in this paragraph.
Hearsay evidence. What does it mean?
Hearsay evidence is when you are talking with something which you yourself did not.
What somebody has told you.
Yes, your worship.
Mm.
So it means even there are some other people whose names are not known who do the things which we don't know.
Mm.
So you will find
Okay.
unknown people.
Okay. Then for the failure to serve, what is the impact?
Now the failure to include that video evidence is in contravention of Article 28
Mm.
and the Article 44C on
Mm.
the non-derogable right to a fair hearing. On the right to non-derogable, on the right to a fair hearing, which requires the opposite party to know exactly what is your case
Mm.
before we start hearing of the matter.
Okay. And what is the impact?
The impact is that the entire paragraph should be expanded from this affidavit, even if the affidavit was to be valid. This paragraph will be expanded in its entirety, and we pray that it is expanded in its entirety from this affidavit.
So you pray only the paragraph be pulled down.
That is on the assumption that if this court is to find this entire affidavit content, because our first objection was on the entire affidavit. So if the court still finds that this affidavit is content, still this paragraph will have to be expanded from this affidavit.
Okay. Go ahead, Counsel.
So your worship, now I go to the affidavit sworn by the Nakiranda Margaret. Your worship, in our affidavit will join that
Affidavit of
Nakiranda Margaret.
Nakiranga.
Nakiranda Margaret.
Nakiranda.
Yes, your worship.
Okay, go ahead.
Yours is our submission that this affidavit is a forgery.
Yes, why?
Your worship will raise this objection in the paragraph 7 of the affidavit in joiner. And the simple reason for this point of law is on the signatures, Your Worship.
Okay. The signature.
Your Worship, the signature of Nakiranda Margaret who signed as the first respondent is polling agent. The signature of Nakiranda Margaret Evans, who signed as the first respondent is polling agent on the declaration form. Is fundamentally different
Yes.
from the signature which is on this affidavit attributed to the same person, swearing as Nakiranda Margaret. That is annexed to the applicant's affidavit in support.
Annexure.
Annexure D,
D.
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 Yes, Your Worship.
So the applicants.
The applicant's affidavit in support of the application.
The affidavit.
In support of the application.
What is annexed there?
That is the declaration form, and it is a common document.
So you're saying that the signature on the
The signature-
affidavit
Yes, Your Worship.
is materially different from the signature on the declaration form. Okay.
Your Worship. Your Worship, and also annexure A, the fact that the second and third respondent is affidavit.
We're still on the repeat that for me.
Your Worship, the declaration form is also attached as annexure A on the second and third respondent is affidavit.
The declaration form.
Yes, Your Worship.
Okay.
So, Your Worship, it is the Court of Appeal in the Court of Appeal in Muyanja Simon Utaya.
Muyanja.
Muyanja Simon
Simon.
Utaya versus Kenneth Lugogo. Kenneth Lugogo
Yes.
and the Electoral Commission. Court of Appeal, Election Appeal,
Court of Appeal.
is Court of Appeal, Election Appeal,
Election appeal.
yes, Your Worship, number 82 of 2016,
Number 82.
number 82 of 2016,
Yes.
the Court of Appeal held that the Court of Law has powers to compare the parties' signatures on the different documents, even in absence of expert evidence.
Party signatures on different documents.
On different documents,
Even without
even without expert evidence.
expert evidence.
In that case, it equally agreed with the High Court's judgment to strike off affidavits which had signatures differing from the ones of the national
They directed to do what?
That is close to over 13.
They directed the
In
High
that
Court does
case,
what?
the Court of Appeal agreed with the High Court's decision, which had struck off affidavits where the deponent's signatures differed from the deponent's signature on the national ID. Your Worship,
Differed from The signatures
The deponent, the signatures on the affidavit
for national IDs.
were fundamentally different from the signatures on the national IDs.
This track of.
So,
Okay. I've taken note.
So, Your Worship, our prayer here is that when you compare the signatures here, without even much difference, these signatures are fundamentally different.
You showed me what you're talking about. But like I said, we should listen, we should be silent. Understood? Because when they are speaking and you speak, we shall lose track. You also want to listen. One said he wanted justice. I wanted to see justice being done. So here, let me see the comparison you're talking about.
So, Your Worship, I take it the affidavit of Nafirananda.
Mm.
That is on the side where she signed as a deponent.
So you want me to compare that signature with which one?
Your Worship, I want you to compare that signature
Mm.
with the signature on the declaration form where the same person signed as the polling agent. That is annexure D, the application issue.
Annexure B.
Annexure D.
B.
Yes, Your Worship. The next page, under which has polling agents.
Mm.
Yes, Your Worship. The same person also signed that.
Mm. Okay, go ahead. Are you done with that point?
Your Worship, we therefore submit that
Mm.
the entire affidavit should be struck out
Yes.
because of these signature irregularities which cast doubt on its integrity.
Entire affidavit is struck off
This part of its entirety.
the record of court. Okay, I've taken note. Uh-huh.
Your Worship, my final objection is now on the affidavit of the second and third respondents.
The final.
Yes, Your Worship.
Respect of the
The affidavit in reply,
mm,
which was sworn by the second and third respondents.
by the second.
By the second and third respondents.
Mm.
Your Worship, we submit that that affidavit is also neutrally effective.
Mm.
Because
Yes.
one
because-
person cannot swear a joint
Now
affidavit.
that is what you're trying to say, but because of what?
Because that affidavit lacks the third respondent's authority.
So it was sworn by one person on behalf of two people.
Yes, Your Worship.
Okay.
Your Worship, it is tried to know that where one party
Mm.
swears an affidavit on behalf of the other party.
Mm-hmm.
There must be evidence of written authority.
There must be.
There must be evidence of written authority
Mm.
authorizing the deponent deponent to swear on behalf of the other.
Yes, go ahead.
And in this case, there is none attached on the affidavit in reply of the second and third respondent.
There is none. Okay.
So, Your Worship, in support of this submission, we cite the case of Kayongo Muhammad. Kayongo Muhammad.
Kayongo
Muhammad.
Mm.
And the two others versus the Administrator General and another
Versus the AG.
versus the Administrator General
Oh.
and another
Mm.
that is High Court Miscellaneous Application number 27
27 of which year?
of 2016.
Okay.
And submit that since the sub-respondent did not authorize
Mm.
the deponent to swear in material facts relating to this matter, then the entire affidavit is actually defective.
Mm. So you pray
We pray, your
that I find the affidavit
being incurably defective.
shown by the second and third. Okay.
Your Honor, my land friend Bani has one more addition on that.
You want to supplement on which one?
The same point.
The same point? Go ahead, Counsel.
Most obliged, Your Worship.
Mm.
For the record, I'm Ruby Hayo Cooper Brian.
Counsel Brian. The other name was?
Ruby
Cooper.
Hayo
Cooper is better. Go ahead, Counsel.
Your Worship, our submission on that is that in absence of the authority to depone,
Mm. Yes.
the effect is that the third respondent in particular
Mm.
does not oppose this application.
Mm.
The third respondent was sued in her own capacity as the returning officer of the election in Kwo.
Okay.
And therefore, evidence sworn by another deponent
Mm.
cannot bind the third respondent.
Okay.
I invite the court
Yes.
to make a finding that all the facts deposited in the application
All the facts.
all the facts, all the evidence in support of the application, or deposited in the affidavit in support of the application,
Mm.
are not controverted by the third respondent. And for that proposition, Your Honor, I rely on the authority
Mm.
of
Yes. Go ahead.
Samuel Massa
Samuel or Samuel.
Samuel in vernacular.
Samuel Massa.
Samuel Massa.
Give me the spelling of Massa.
M-A-S-S-A.
Okay, Massa.
Versus Rose Achane.
Rose
Rose Achane.
Achane. Okay.
1978. Square bracket HCB. At page 297.
Okay.
Your Worship, that's a locus clusters authority on the principle that if facts are deposited in an affidavit and are not controverted by the opposite party, they are deemed and presumed by the court to be true.
Okay. Is that all? On the clarification or the addition?
Your Worship, that's all on that particular point.
Maybe you enlighten me on because you told the court that the presumption is the third respondent did not challenge the facts since she never put in an affidavit in reply. Now, what happens to the second respondent? Because the affidavit was sworn by the second respondent on their own behalf and on behalf of the third respondent. But you seem to argue to the effect that it is only the third respondent who has not opposed the application. How about the second respondent?
Your Worship, our submission is that as a result of that, the entire affidavit collapses. Maybe at that point, the second respondent is
Why
also not
would that
opposing
the
the-
second respondent collapse?
Yes, Your Worship.
Why would
Because an
the
affidavit.
affirmance in respect of the
Because
second
that
respondent collapse?
affidavit does not comply with the law.
So
And
here, because you seem to zero on. Anyway, that was your addition.
That was my next link of the argument.
Okay, thank you.
The affidavit
Does not comply with the law.
comply with the law,
Okay.
and the worship, the laws are Order 1, Rule 12 of the Civil Procedure Rules.
Order 1, Rule 12. What does it say?
Appearance, if I may read,
You can paraphrase in brief.
the rule here, Rule 12, requires that for one to appear on behalf and to give evidence to prosecute a matter, he or she must do so with the written authority of the co-respondent.
Repeat that. Or you can read it.
I
Just
am
read it.
paraphrasing you.
You can read as it is.
Rule 12, appearance of one of several plaintiffs or defendants for others, where there are more plaintiffs than one, or one or more of them may be authorized by any other of them to appear, plead, or
Okay.
act for that other in any proceeding. So our submission, it goes on. Our submission
Okay.
on that is that there is no party before court with the authority from the third respondent to appear and do anything on her behalf. That's our submission.
Okay.
Before I leave that point, Your Worship, I would like to highlight the importance of the third respondent in the dispute at hand.
Okay.
Your Worship, the third respondent is the returning officer of this election. She is clothed or seized or conferred upon various statutory duties under the Parliamentary Elections Act.
Okay.
For instance, I will highlight the sections. She has, under section 77 of the Parliamentary Act, a duty to declare the winning candidate.
Go ahead.
She has a duty. Your Speaker, briefly may be put on record.
Fine. I was digesting.
Most obliged. Your Worship, maybe I can first explain it and then I simplify it for the document. The crux of my submission here is that she has statutory obligations. One of them is to declare who the winning candidate is. One of them is that if there is any conflict, there are statutory mechanisms under the PEA, Parliamentary Elections Act, the mandatory recount before we come to the court. All those matters are within her hand. So therefore, her appearance in an application of this nature as the third respondent is deeply rooted within the statutory provisions of the Parliamentary Elections Act.
Okay.
And in exercising those statutory mandates, she is not subject to any control. Even of the Electoral Commission of the second respondent. In declaring who the winner is, in deciding whether to have a mandatory recount as provided for under the law, she is autonomous. And Your Worship, in absence of a written authority as dictated by law, vis-a-vis the crucial statutory rules of the third respondent, I invite the court to strike out any affidavit that imposes facts on the third respondent.
Yes, point noted.
Your Worship, the last one, this is not an objection per se, but would seek your
In
indulgence.
addition to the same point of law? Or
No, Your Worship, now I seek your indulgence on the affidavit by Mwesibo Aaron John, in far as it relates to introducing video evidence. I just want to indicate that we reserve our right to raise a preliminary objection in respect to that.
no, it was raised already.
No, in respect to the admissibility of that evidence and whatever.
He wants the affidavit to be struck off.
Your Worship, what I'm saying is
Because
that
we would resolve that
most obliged.
after resolving the PO on whether we are striking out the affidavit entirely, or one of the paragraphs that was talking about extracting the video. So it is after.
So, Your Worship, on that one, I simply wanted to
Okay.
indicate that we
Okay.
intend to raise. Lastly, Your Worship, now the affidavits of Mhumza Julia.
It's another PO.
Yes, the last one.
This is going to be the fifth PO.
There are not quite many who are close to the count.
I had so far captured 4 points of law. This is going to be the fifth.
Yes.
Yes. Yes.
Your Worship, our
Affidavit of who?
the affidavits of Mhumza Julia
Muhumuza Julia.
and the Nachiranda Margaret Elioth, and also the affidavit of Mwesgwa Alan John. The summary of the submission or point of note that is that those 3 affidavits suffer duplicity of evidence.
So
They-
you're
They,
doing a summary of the 3 affidavits.
yes, because I'm going to submit on them, I will indicate the paragraphs.
Okay.
By duplicity, Your Worship, we mean that they regurgitate, they repeat in the same words narrations of one event, but observed by 3 independent persons.
So they state exactly.
They repeat exactly the same words
Yes.
in the same order. A narration of the same event but observed by 3 human beings.
Okay.
And Your Worship, I invite you to look at paragraph 6 of Mwesgwa Alan's John affidavit. Paragraph 6
of
of Mwesgwa Alan John's affidavit
yes.
is exactly the same wording as paragraph 5 of Mhumza Julia's affidavit.
Muhumuza
Is
Julia.
Mhumza Julia's affidavit.
Muhumuza Julia.
And is also the same as paragraph 7 of Nachiranda Margaret Elioth's affidavit.
Nakiranda.
Nakiranda Margaret Elioth.
Which paragraph for Nakiranda Margaret?
For Nachiranda, it's paragraph 7.
Okay. Yes.
Your Worship, paragraph 7 of Mhumza Julia again is exactly the same in wording. No missing any word, order, point, full stop, comma.
Exactly.
Is exactly the same in wording as paragraph 9 of Nachiranda Margaret Elioth's affidavit.
Nakiranda.
Yes. worship, our submission on that is that that offends Order 19. Order 19. Rule 3. Which confines, just by making the point to emphasize confines, which confines,
You want me to bond?
it's my prayer, Your Worship.
Okay.
It confines matters of a deponent to his or her own knowledge. To his or her own knowledge. Your Worship, it is not humanly possible it is not humanly possible to invite 3 people to narrate events, to give a narration of events, and they are using the same words.
Yes.
In the same wording. That is order and the arrangement of words. We invite the court to find that these 3 witnesses were coached. They were coached, told what to say, either told what to say, and we invite the court to strike out those affidavits for being non-compliant with the law.
For the paragraphs or the entire affidavit?
Your Worship, we invite the court to reject all the affidavits.
In the entirety?
Yeah, in the entirety. But in the unlikely event that the court
Yes.
holds otherwise in throwing them in their entirety, we pray that those particular paragraphs be struck out. Lastly, on that point, Your Worship, and in summation for our POs, is that an affidavit which offends the law an affidavit which offends
You're
the
still
law.
on the same.
Yeah, but I'm summing up. An affidavit which
Okay.
offends the law
Mm.
cannot be cured. It cannot be cured. And Your Worship, on that, I invite the court to look at the case of Kasala Growers.
Kasara.
Kasala Growers.
Give me the spelling of Kasara.
It's K-A-S-A-A.
K-A-S-A-A.
K-A-S-A-A-L-A
L-A.
versus
Kasala Growers.
Yes, Kasala Growers. K-A-S-A-A-L-A Growers Cooperative Society. And Kapoza Jonathan. Versus Kapoza Jonathan. And another.
Yes.
It's a Supreme Court civil application number 19. Of 2010.
19 of?
Of 2010. So, Your Worship, for those objections,
You have the authority, and what is it discussing basically?
Your Worship, in that case, the court drew the distinction between what amounts to a defective affidavit, which can be cured, like for example, an affidavit that is not dated. The court can order the witness to date it. But an affidavit that does not comply with the law, it's stated there, it cannot be cured. And our submission is that the affidavit of Mumza Julia Nachilanda Margaret and Mweswa Alan, they offend Rule 19, so they cannot be cured. Yes.
And Rule 19 says?
Order 19, Rule 3, it confines facts that can be deponed to an affidavit to an individual's personal knowledge.
Then maybe you enlightened me. There is where you submitted to the effect that it is not possible for a human being to narrate events of the same period using the same words and in the same wording. That I don't know, where do you get that? I want the authority. It's not mainly possible. Which authority? Where do you get that? Is it your opinion? Is it
My Lord,
where do you get that?
My Lord, I'm trying to recall the textbook, either Saka or evidence. But my Lord, it's that there are rules.
Which rules?
The rules of whether a witness is reliable, the rules of whether the affidavit meets the test.
Okay.
Order.
You look around. Good enough, you are many lawyers.
Look, but Your Worship,
You have the authority.
Your Worship, it is also my opinion, but it can also be an ocular observation under the Evidence Act. Evidence also includes ocular observation, section 2.
So
and I'm inviting the court to observe that naturally, I'm inviting you, Your Worship, to make an ocular observation. It's allowed under the law, under the Evidence Act. That you cannot invite 3 people to narrate what has happened in the market, and they are using the same words in the same order without any deviation. If any other person from a humanly perspective has then...
No, my point was, where do I get that conclusion?
My Lord, it falls naturally.
Naturally.
Yes, it falls naturally. Yes, my Lord, the court will return and take time and analyze it. But my submission on that is that it's not humanly possible.
Okay.
Yes.
Okay. Thank you.
So,
maybe before you take leave, the authority you have just cited, have you availed this to the opposite party and court?
Your Worship, the last one for Kasala Growers, I've not availed it, but Your Worship,
how about the other authorities you cited?
the other authorities of Muyanja Simon, we have availed the opposite party.
Did you highlight the pages? Or you want us
We
to
indicated the pages on top.
on both? Yeah, there is no page.
I wrote the last authority for Kasala Road, the one I have not appealed to the court. But I,
Now for the ruling in MA 27 of 2016, you
That's
highlighted
kind of-
page 4.
yes, I'm there.
Yeah, when I read it, I don't seem to pick out anything at that point alone, where you have highlighted.
I beg your pardon?
MA 27 of 2016, page
Yes.
4, you have highlighted. I'm trying to read the area you have highlighted.
Thus, in absence of written authority, there
Yeah,
is
I think-
paragraph.
I think that is what was the intention of. The area you have highlighted.
Yes, Your Worship. It reads.
Does it talk about the area of interest?
What I can guide, and the one who cited it is at page 4, the second paragraph from top. Thus, in the absence of written authority from the second respondent, Mr. Mutavia Serra, to record the affidavit on his behalf, or as an advocate or hold the power of
Yeah, maybe you had left out this paragraph. You see what you had highlighted for me. So I was so specific in the interest of time.
Yes, sir, outside the worship.
Okay.
So, Your Worship,
Maybe before. Is this the latest authority? Do we have authorities that depart from this position?
Your worship, because of time constraints, because you are served at night, so that is the biggest authority.
No, but my question is this the latest position, or we have authorities that have departed from this?
Well, there are very many even of this year and last year.
No. I mean, we have authorities departing from this. We have authorities from Superior Court that have settled the matter.
No, I'm not aware of any of this.
So you think this is the latest?
Your Worship, let me make an address.
This is the current law.
That position has not changed.
They are not changed. Okay.
Your Worship, if I may, the problem is that I don't know where the court is pointing at.
No. For my information, I just want to be very sure that is this the latest authority? Is this the current legal possession? Because we are not going to go here.
Your Worship, this remains
The current
the current position.
of the law.
Yes, Your Worship, I know, however, for off the record, that there is a whole debate of decisions, and you will find a decision which attempts to a decision by Justice Wamala Boniface, or a decision by Brother Kero sitting at the board. Those decisions tend to say, for example, in land matters, that if you sue unlogiously, I'm just giving an example, that if you sue someone, let's say for land, and someone else has facts about that land, that person can swear an affidavit to state the facts relating to that dispute. But now, when it comes to matters of appearance, for example, and in matters like this, where someone has a legal standing and a statutory duty, and a power which they cannot delegate, that's why I was referring the courts to section 77 of the Parliamentary Elections Act, is that unless there is an express authority written And the court also has to interrogate whether, to that extent, the third respondent can give an authority for any person to come and testify on matters relating to her exercise of statutory duty. So I know, Your Worship, you will be referred, I have argued with some of my colleagues on the other side. I know you will be referred to those cases to try to distinguish that, no, if someone knows the facts, then they can come and testify. A returning officer has a statutory duty to depose to the facts relating to an election where she is a returning officer. No any other person can do so. That's why we are tagging it to those specific sections.
Okay, I've taken note.
So, Your Worship, our submission is that on the objections we have raised, the court finds that those affidavits do not comply with the law,
Okay.
and invite the court to strike them off the record. We so pray, Your Worship.
Okay. Counsel, this is counsel?
Kama David Yoshi.
Come on. Go ahead with the response.
Yeah, I'm ready, Your Worship. I'll make a submission, then my grand senior brother will adjourn. With my other brothers.
Will you follow the order they were raised?
Yeah,
follow the
I'll
order
go
they
by
were
that
raised?
order,
Okay.
and then my grand senior brother will follow.
Right.
Okay. Your Worship, the first one is that the media observer does not attach his letter of accreditation.
That is, what is the name?
That is Mesugwa.
Mesugwa?
Mesugwa.
Alan.
Mesugwa Alan.
Not attaching.
His letter of accreditation.
Letter of accreditation.
Yes, yes.
Mhm.
Your Worship, our humble reply that that objection is not legally grounded.
Before it not being legally grounded, do you admit that he never attached?
Your Worship, the affidavit is not having, other than having a video evidence, it is not having an attachment of him being an observer.
Okay, it's not attached, but
Your Worship, it's that criminal objection is not legally grounded. Your Worship, Order 19, my land of Order 19, the civil procedure rules,
Order 19.
the civil procedure rules, which my land brothers have cited. But under Rule 3, it states the contents of an affidavit and does not create an offense. For failure to attach such authority. And Your Worship, under Rule 2 of the same order, if the other party finds it offensive not doing so, it can be cured by cross-examination.
So you're saying it's not enough, the failure to attach does not contravene
The law at all. And in case there is any aspect which the other party feels has not been well clarified by the affidavit. The same order gives a mechanism of how it can be handled. That includes requesting for him to be cross-examined on some of those facts.
The facts are not available.
If some facts are not very clear, or the other party has some doubt, he can have the said deponent cross-examined.
Okay. So you're saying they can be cured through cross-examination?
If it's not, my first belief is that it's not a defect. Then to that, in the event
Okay.
the other party finds those facts important, there is a clear available remedy under the law, and it can be cured.
Through cross-exam.
It can be, yeah, those facts can be verified through cross-examination.
Okay.
Yeah. And
That is the red line in respect to the first point of law.
first point of law. Then they proceed to go to paragraph 5, that the video was not served, and therefore that paragraph is offensive. It should be struck out. Your Worship, my land brothers have forgotten so fast. That they were before you on 11th.
Okay, for starters, was it served before you submit that directive?
Your Worship, it's on court record.
No. It's not, they did not say it was not on court record. They say they were not served. Were they served?
Your Worship, I'm going by the order this court gave. It was not, did not provide for physical because of the timelines.
No. Take it. You're going to submit on that. I just want to know.
Your Worship, it was not served.
Okay. So you maintain it is true, it was
Not served.
never served,
Your Worship, that failure was created by the directive of this court, which was obtained ex parte by Myran Brothers. It provided service by WhatsApp as a mode of service. Your Worship, the size and mode of that video could not be compressed to be made an attachment.
The size?
Of the video could not be compressed to be sent by WhatsApp. And of course, to array the affairs, Your Worship, we intend to make an application that that video is played in this honorable court.
Maybe before that. What do you mean it could not be compressed?
By its
Where did you
size.
get that?
By its size, it was so hard to compress it and serve it by mode of WhatsApp.
Okay.
Yes.
So you are
And
adding
unfortunately, we are not given emails, which would have been the alternative solution. It was only by WhatsApp, and we had only their numbers. And could not
So
be-
you're saying WhatsApp has a limit?
has a limit of the size of document you can easily download and send.
Since WhatsApp
It's limited,
is limited,
and the video is big.
limited on the videos, the size of video.
The size of what you can send on it.
Where do you get that?
My word, I have a benefit of having tried to be high-tech a bit. But then, if that aspect can be obtained from the witness through the
No,
resolution.
you making the submission, where do you get that?
Your Worship, over time,
Practice.
it's practice. WhatsApp has a limit on what you can send on it. Actually, in most cases, That's why email becomes an alternative. That's why you can put any size, but WhatsApp has limitation.
Okay. Go ahead.
Actually, to make it clearer, that WhatsApp is an item on a phone, is an app on a phone, and the phone itself has capacity. So a video that is equal or bigger than the capacity of the phone cannot be, or close to, cannot be compressed to be used on WhatsApp.
I have no problem with
Okay.
that submission. The only problem I have is where do you get that? Because as far as I know, if you allege, you prove, where do you get that from? That submission.
Your Worship, this is a matter of that court should be taking judicial notice of. Court and the lawyers,
You take
including,
judicial notice.
yes, Your Worship, that every owner of a phone knows that the phone has limited space. It is not unlimited. And therefore, when you are loading data on it, it must comprise the limited space available. And
So it is by common knowledge.
common knowledge, it's whoever has a phone has common knowledge
or you are an
that it has limitation.
Or you are an expert in that area.
No, Your Worship, it's a matter of common knowledge.
Okay, go ahead.
Be the actual video you're relying on.
Still common knowledge.
I'm likely to have gotten some little knowledge, but then
Okay. Okay, I've taken note of that point. Go ahead. Maybe.
actually, Your Worship, for the record, this video, you understand, is about 1 hour, which is close to 8 GB.
Okay, maybe I want to address the area of the impact.
Your Worship, I said that you stopped me when saying that allay their fears.
Go ahead.
To allay their fears, Your Worship, we intend to make an application to this honorable court that this video
Okay, before that,
is.
because that application will come at the right time, but I wanted to know, your submission was that the non-service is contravening the principles of a fair hearing. And for that matter, they were making a prayer that we strike it off since they have not been afforded that fair hearing. Well, at least you have admitted it was not served on them.
See, Your Worship, my land brothers appreciate the expediency this court had. Otherwise, under ordinary law and practice, the time of reply by affidavits, the mode of service is supposed to be by physical service. And had we gone by physical service, Your Worship, that video would have been served to them. But once they made their own application to court, that limited the service to be electronic.
Okay, you see what I'm trying to get on get you to my feed is that we admit it was not served until then.
Yes. But Your Worship, it's available to be served on them.
Okay, so
Your Worship, it's available to be served on them. And it was not an intended it was not an intended aspect of trial by ambush. But it was created by the unique nature of service this court
okay.
opted for. And
So you say
surveyed.
the same is on court record?
And Your Worship, the same is on court to record. Your Worship, for the record, up to now we have not been served with the physical application, but we are not complaining.
And you want to proceed over the same when you've not been served?
Your Worship, we took the mode of service this court adopted, and we also
Okay, I've
adopted the
taken
same.
note. Only that you've told me you've not served here and you're not complaining. You should complain. You have your right to complain.
Your Worship, we are saying that we want this court to proceed and finish the matter.
Okay.
For us,
Okay, I'm taking note.
mm,
Okay.
we have not been prejudiced, and what they lack, the applicants will be there. They will be served.
So at least you say you intend to serve them.
Actually, it's when we go to record, they can obtain a copy. We can also give them a copy if they feel it is necessary.
So you're going to serve them.
We are going to serve them.
Okay.
And Your Worship, so Your Worship, it's our humble submission that no, there was also an attack on the deponent using the word we. An attack on the usage of the word we while referring the way the
By the way, on the extraction
this of extraction.
of the video.
Your Worship, from the beginning of this affidavit, the deponent states that he was not on an errand of his own.
That is paragraph what?
Your Worship, when you go to paragraph 1,
That is the affidavit of Alan.
of Mr. J. Alan John,
Yes.
the deponent makes it clear that he was not on the frolic of his own, but was rather assigned by his employers, Next Media House. Then, so Your Worship, reference the use of the word we in paragraph 5 is in reference to the company.
I hope you will not give evidence from the back.
No, Your Worship, we are only explaining the word we. We are not giving evidence from the back.
So you want to interpret the meaning of we?
Your Worship, actually, we're inviting this court
To interpret
to look at the usage of word we in paragraph 5.
meant
It meant the owner of the work, which is Next Media,
of we in para
refer to,
meant
it was reference to Next Media House, commonly known as NBS,
referred to Next Media.
commonly known as NBS.
Okay.
And Your Worship, to make it clearer, the deponents has not said that we swear, refer to a part of work. When it comes to swear, he states it clearly under paragraph 8 that I swear this affidavit. It's him alone who's making the affidavit, not.
So we, in terms of extraction, what does that mean?
It was referring to staff of Next Media, him among others. We are doing this
The
work.
extraction,
Yes.
not him alone.
No. And being present during extraction is a competent person
Okay.
to depone about that government, Your Worship.
Okay.
Your Worship, my young brother, thereafter he moved to the affidavit of Natural and Margaret.
Nakiranda.
Nakiranda, Margaret. Worship, the offense there really that, according to my young brothers, that our signature is fundamentally different. And of course, my young brother relies on the case of me and Simon Rutaya. Was that page what? But if I could, from what I discovered from reading that case, the comparison was the signature against the affidavit. Sorry, no, the signature against the national identity card.
Yeah. In that case.
In that case, the distinction was against the national identity card.
Yeah.
Your Worship, that is the official document. And we are seeing the indulgence of this court.
Yeah.
We are seeing the indulgence of this court. That since this court was called upon to make comparison as an expert, we request that we provide the national identity card, the state natural.
So you're saying that in the authority
Of the authority they have relied upon of Muyanja Simon Rutaya.
relied upon Simon
Of Muyanja Simon Rutaya.
Muyanja
Muyanja Simon Rutaya versus Kenneth Rwogo and EC.
the comparison
Was between the signature of the affidavit,
between the
signature on the affidavit, and the signature on the national identity card.
so it has it.
Your Worship, since this court was invited to make a comparison, we make a request that this comparison is made in tandem with the wording of the authority, by also looking at the national identity card of the deponent.
So you invite courts to
Look at the national ID of the deponent, which we have for us. And second, Your Worship, we have the deponent in court. These are simple matters of clarity when it comes to signing and not signing. The deponent is here in court.
okay.
So we leave.
Before I get to that area, I want to appreciate. Do you admit or concede that there is a material difference between the signature on the affidavit as well as the signature on the declaration form? Because that is what was alleged.
Your Worship,
Address that.
Your Worship, I don't want to assume expertise in documents.
But you cannot tell whether there is a material difference or not.
Your Worship, personally, I cannot tell. I don't